case, General, but explain to me how this case changes the result at all. That Lomax case changed the result at all. You had people in a vehicle um, where the defendant was accused of driving the vehicle, and the court gave an instruction on criminal responsibility for driving under the influence, correct? Which was the indicted charge. How is Gavin criminally responsible in this case for the neglect, which is what is indicted?
I'm not saying that Gavin is criminally responsible. I'm saying that she is criminally responsible for Gavin's actions.
Okay, how does criminal responsibility fit? How did Gavin commit neglect?
I don't think he did.
It appears to be that I can't be responsible for someone else's criminal act if they are not acting criminally. That is the issue. How did he?
I don't completely agree with that, but the problem is one about how this case is indicted, because the predicate felony here is neglect, not abuse. Had you indicted for abuse as well, I think you would have a much more compelling argument that she is criminally responsible for Gavin.
So, in other words, he's saying that if she said neglect should win over abuse. Abuse is neglect. So I don't see what's the difference. Conduct.
Language, at least it creates a factual question for the jury to resolve. But I have to be able to say that Gavin is criminally responsible for the neglect as well as pulling the trigger.
That's not what I'm asking the court to do. I'm asking the court to give an instruction that she is criminally responsible for the actions of
the mother. She said that what the state is saying, that the mother is responsible for what happened to Gabby, not Gabby, Judge. She trying to say that you know what she's saying. Jesus.
way around. That Miss
I
Howington.
understand that, but there has to be. But the predicate felony, I don't know how many times I have to keep saying this, the predicate felony is one of neglect. Mm-hmm. That's how you get to a felony murder prosecution in this case.
Say neglect then.
We'll take 5 minutes and I'll go back and read this case in its entirety. I don't see it. I'll give you that much.
Say neglect. I tell you what, that's what you do then. Just say neglect. What he's saying, neglect. That's what it is. Neglect is abuse. Abuse a situation. Listen.
You ready to bring the jury in and argue this case?
There's just one more thing that I want to address with the court. So I know obviously that this is a case that involves highly emotional subjects. What we would ask is that the court instruct any family members, including the defendant, to please try and control their emotions when the parties are giving closing arguments, just like we do victims and their families. I think that's a fair request.
Anyone within the courtroom that's in front or behind the bench, or the bar rather. This is a critical point in the trial for both sides to be able to advocate their position to this jury, and the jury needs to be able to hear everything that's being said and argued. So do your very best to control your emotions.
That's right. Control your emotions.
Forth, attempt to do so as quietly as humanly possible.
Your Honor, sorry, just one last thing. Can we also refrain from discussing punishment and or asking the jury to put themselves in the defendant's shoes? I think there were a couple of statements made in opening to that effect, so we would just ask that that not be brought up here.
Punishment clearly out of bounds and off limits. That's for the court to decide. She's convicted of first-degree felony murder. The punishment's automatic, but that's clear law that that's not a part of what their task is to worry about what her punishment is. Their task is to decide whether or not the state has proven each and every element in this case beyond a reasonable doubt. So stay away from those topics. Let's argue this case. Get the jury lined up.
for many years, I've been trying cases against you and in front of you that's happened. I'll keep that in mind.
Many years of what?
Trying cases both against you and with and in front of you that
Well, we tried a couple with each other too.
That's what I said. Well, against you, is that right?
I think the only thing you've established, Mr. Whalen, is that you and I are both pretty old.
I don't think I was hiding that anyway.
I don't know about y'all two. I don't know about what y'all saying. All this grumbling.
Time constraints on either side, but don't belabor points, get to them.
Why is he all over there with the state? I wouldn't want nobody standing behind my back. Stay on your side. I'm talking about the defense attorney, y'all. I don't want you all behind my back whispering stuff. Stay on there on your side.
All rise for the jury.
Stand where I'm getting all this light from. That judge know he tall, ain't he, y'all? Like he about 7 feet.
Everyone may have a seat. Waive the call for the state for the defense. Good morning, ladies and gentlemen. I apologize. We kept you waiting a little bit longer than we thought we were going to. We were ready to start argument in this case. Blame me. I was the reason that we had to take a little bit longer. Let's talk a couple minutes about closing argument, and then I'm going to turn the floor over to the attorneys. Because the state has the burden of proof in this, as in every criminal case, you will hear first and last from the state. You will hear one time on behalf of Ms. Howington by Mr. Whalen. I want you to listen very carefully to what each of the lawyers argue to you. They know their case. They can point you to facts which they believe have been established within this record, as well as inferences that you may draw from those facts in order to assist you in your deliberative process when you get this case here in a couple hours from the court. I want to remind you, however, that what the lawyers say is not evidence. The evidence that you must base your verdict upon in this case must have come from this witness stand or from an exhibit introduced through the various witnesses who have testified or by stipulation or agreement of the parties. The state has the burden of proof. General McDermott, you are recognized on behalf of the state of Tennessee for your opening argument.
September 14th, 2019. Destiny Oliver, 5 years old, 56 pounds, 48 inches,
She need a microphone.
shot and killed by her mother's Robin Howington's home. In this case, ladies and gentlemen, is about this one. That's what this is. It's about what happened to this
Where the microphone?
on Balsam Drive on September 14th of 2019. You all heard all the testimony in this case. You've heard all the witnesses. As it mentioned to you, the proof in this case has shown that Robin Howington's negligence, her negligence, as tragic as this is, but this was a mistake. Her negligence is the reason this child is no longer in this world. I want to talk about the night of September 2019. What was just revealed? You all heard testimony in this case about what she was doing. She was at a park, according to Ms. Howington. It was her, her mother, and her 2-year-old little brother. So the park that day, Jen never came home. We heard whenever she got home, that she was hungry, she hadn't eaten that night. And so what Destiny was doing at her home on Boston Drive, right before this incident happened, is she is sitting on her couch. She is watching TV with a remote control in her hand. And this little girl is waiting for her dinner. And she has no idea about what's getting ready to happen. As she sat there on the couch with the remote in her hand, a gun was fired, and that bullet came out of the gun, went into her hand, out of her hand, into the remote, into her chest, out the back of her body, and into that person. We heard from the testimony in this case what else came out of that gun besides that bullet out of the Destiny's body. We heard that there was gunshot rescue persons. You will hear the testimony of Kyle Osborne, the TBI agent, who testified about how gunshots work, about when that trigger hits the back of the cartridge, there's projectile that's expanded, and then there's fire and gunpowder, and then out of that gun, through the cracks in the gun, as you heard that officer testify, comes these tiny microscopic particles. He testified that when a gun is fired, those particles go about 5 or 6 feet from the gun where the gun is fired, and then they settle there. There's 3 different ways that gunshot rescue particles can go in a person's body. If you fire a weapon, if you are in close proximity, 5 to 6 feet of a weapon when it's fired. And then he also testified that you can get gunshot particles on you if you touch somebody that has gunshot particles on them. So what do we know in this case that happened? We know that Gavin, 2-year-old, has gunshot particles on him, on his clothing, on the front of his little Nike t-shirt, if you all saw it. And we know the defendant has gunshot rescue, gunshot particles on him. And so we know those 3 things have to be what happened in this case. Fired a weapon, or in close proximity to the weapon, or touched someone who did one of those 2 things. So that's the proof that you all heard. That's what we know from that particular part of the case. So I want to shift for a second, and I want to talk about the other things that we absolutely know in this case. Because I submit to you that the defendant has told so many stories, so many different stories, that you're not going to be able to rely on what she says happened that night. You can't. She's told too many stories for it to be reasonable for you all to believe what she said. So let's start with what we absolutely know in this case. You all watched the video in this case, the video from the neighbor's camera. It was grainy and it was kind of boring, and we watched it for a long time. I'm sure it wasn't the most dynamic, interesting part of this case. But that video, ladies and gentlemen, is very important. Very important. And the reason the video is important is because it establishes that there are people there, and there are people going in and out of that house. And it also establishes how long the people were in the house and how many times they've been out. And so that's why we're going to start with that. So the video that you watched, if you'll recall, there is a car that arrives at the beginning of that video. And I'm not going to make you watch it, watch the whole thing here again, because you guys have already done that. You will have that video back in the jury room. You may watch it at your pleasure as many times as you want during the duration. But what we saw in that video was that there was a car that arrived at 8:29:38 that leaves at 8:31:08. And then you can see that there's a car that arrives at 8:31:04, and that's going to be this car, the one with the green arrow in it up on the screen. And that car, we don't know if it's the same car as this one or if it's a different car. But we know that person that was in the car sat there with their lights on from 8:41:04 until later on, and we'll get to that. So the next thing that happens, the next part of the video that's important is this part that I have up on the screen. This portion of the video is whenever the defendant, Robbie Howington, gets to the house, and she gets there at 8:42:43. So when she's there, that vehicle is waiting for her. That's uncontroversial. That's what happened. And we know that because a neighbor happens to have.
She might not want that little girl.
The next thing that you see on that video is that Destiny then walks inside the house. She goes first. She walks in at 8:43:28. She walks inside her home. It's kind of the last time that this little girl goes into her home.
Mm.
And she's followed thereafter by Miss Howington, who is carrying it. Destiny goes in, Miss Howington goes in. And then there are several minutes that this person who is in this car is sitting outside. It's not a situation where that person comes and helps her with the kids, helps her in, and just has her money real quick, and over for car change to put in. No, that person waits. And they wait several minutes for her to get in with her children. 8:46:05. You might have to watch the video more than one time. It's a little difficult to see. You will see right before 8:46:05 that the door is closed, right here. And at 8:46:05 there's activity and that door is open. And I submit to you what's happening there. Sometimes it's calling that person. Okay, it's okay now to come into my house. And then the person in the car walks up to the house and goes in. You all will see in that video, you've already seen, the individual goes in at 8:46:43 and remains in that house till 8:47:47, which is 63 seconds.
63 seconds.
And the reason that's important is because the defendant doesn't know about this video when she's talking to the police. The defendant doesn't know that the comings and goings of the people at the house has been recorded.
So that will be any testimony about when Miss Howington knew that video.
This is final argument.
Miss Howington,
Okay, your objections now.
until the second interview, police come in with their laptop and show her portions of that video. When she makes her initial statements, she has no idea that what happened at that house has been recorded. And that there's only 63 seconds that this person is in there. And that's important. That's important. Because it shows that the stories about what's happening inside the house are not true. Are not true. She can't come into this courtroom and say, oh, there's this fight with Anton, and there's this big struggle with the gun, and all these things that are happening. She can't say that anymore. It's not true, first of all. It's not backed up by the video that you all were able to see because the neighbor happened to have a video camera next door to 502 Folsom Drive. You all saw in that video that person comes in calm, walks away calm. Now what's the next thing that happens? The defendant exits her home. She does that at 8:48:52. She leaves her home. She leaves her two children inside her house, unattended, which is fine to do, unless you have a loaded firearm in a place for a child who easily access. she knows nothing about me. And she wants you to think, and we'll get to this in a minute, she wants you to think, oh, that gun's up in the top of the house. Or that gun's somewhere else. The child had to have gotten on a stool and reached up to the closet and gotten from the top of the closet.
Hey, Chad.
Figure out what's just happened. I submit to you that what's just happened, consistent with what we heard about Miss Howington, is that there is a drug transaction that happens. That person waits outside for 3 minutes so that she can get her kids into the house and out of the way, so that he can come in or she can come in. She has that gun there when this transaction happens. You'll her investigative things. You'll heard him testify in his numerous years of law enforcement experience about how drug transactions happen quickly, and that often there are firearms there for the protection of the person who is selling the drugs or the person that's selling. And I submit to you that's why the gun was out there. And the person responsible for that gun, where it was, is not Destiny, it's not Gavin, it's not these law enforcement officers, the best ones to blame for everything that happened. The person responsible for where her gun is that night is this lady, Miss Howington. Miss Howington leaves her home, 8:52, returns after she moves her car. You all saw that on the video. She moves her car. Takes a couple minutes to do that, and then she goes back inside. After she gets in the home, there's about 3 minutes before she calls 911. Here's the portion of the video where she is calling 911. And this is important. It's important because when she calls 911, what is she doing? What are her actions? First of all, it's important to know that when she calls 911, her reaction to her child that has just been shot and who is mortally wounded, her reaction to that is not to get on the phone and tell the 911 operator exactly what's happened. Her choice, her decisions, her actions, her words to the 911 operator are lies. She decides. This detective doesn't make her say anything to 911. Detective Wardwell doesn't make her say anything to 911. Miss Howington is responsible for her actions and for her words. And her immediate response, her child being shot in the chest, her immediate response to get on the phone and call 911 and start spinning a story. Start blaming it on someone else. Why? Why? Ask yourself, why would she do that? Why would she do that? Miss Howington lies to 911 and spins this web of lies because she's trying to protect Gavin. She does these things because she's trying to protect herself. She's trying to protect Robin Howington. And she knows right away when she's on the phone with 911, right away, that leaving her gun out and allowing her children access to her gun is her fault. And it's tragic. You will not hear the state say if she purposely shot her child or she wanted this to happen. That's not what we're saying. What we are saying and what the proof shows in this case is that Destiny died because of her negligence. This was an avoidable death. Howington is responsible.
She is responsible though.
Sad as it is. So let's talk about this 911 call. What I'm going to show you is the clip of the house outside synced with the 911 call.
On Saturday, September 14, 2019, at 8:53 p.m., with a PM offset of negative 240 minutes, agent ID, extension is 202.
I apologize, Mayor. I have not been shown this demonstrative piece that is linked in two separate incidents, so that I could test myself whether or not it's directly linked up.
It's final argument, both of these pieces of evidence are in the record.
On Saturday, September 14, 2019, at 8:53 p.m., with a PM offset of negative 240 minutes, agent ID, extension is 202. I'm on an emergency. This dude was just at my house and my fucking daughter just got shot, man. Please hurry. I'm the mother of the Boston Drive.
What, she just got shot right now?
Yes.
Who did it? The guy that's walking to your door?
She did it. She did it.
Okay, what's your name now?
Robin.
Robin, okay, where's your daughter at now?
She's on the top.
Where did you shoot her at? In her arm?
It's in my chest.
Okay. We're on our way, I've already sent it, Robin, we're on our way down. She's laying on the bed. Oh, we're coming, Miss Robin, let me let you speak with Mandarin, sir. The guy who did that, his white legs are standing.
He was black.
Okay, what was he wearing?
He had a white shirt on.
Okay. Did he say anything when you opened, did you guys open the door?
She making that up, y'all.
No.
Okay.
And you can hear that.
So,
My baby's just like, oh my God, please come down, please come
we're coming, we're on our way, Miss Robin, let me speak to the ambulance, so let's take what we're trying to get us help for 1 minute for him.
Oh my God, yes.
We're on our way, we're on food, and we're in a car, Miss Robin.
He was in a car, he was in a black bike, so I just opened up the door.
She just lying.
Hey, my son, is it an emergency? Doctor, two Boston Jobs. Okay, telephone number 951-8096. Yes, ma'am. Okay, I already have an ambulance on the way there. Tell me exactly what's going on. I had a man that just came to the fucking door, man, and he fucking, I don't know what the hell happened. The door was unlocked, and he came in here, and he fucking shot my daughter, dude, and she's laying here, she's not fucking breathing, dude, please come. She's not breathing? No. Okay, do you want to try to take CPR? Please, just come in, let's just talk about everything. She is breathing.
You know what you did. You know what you did to your daughter.
How old is she?
That's why you can't sit there and listen.
How old? 5. 5? Yes. Okay. I've got help on the way. I've been on the way since you said it first call, okay? Is that why you're crying? No, that's my son. That's your son. Okay. Yes. Okay. You're coming to you as fast as I can, I promise. Okay, you said she is breathing. Is she able to speak to you at all? Is she conscious at all? No. No. That's me.
She acting now, y'all.
Okay, you have no idea who it was that shot her? No, I didn't know. My door was locked. Okay. They're here now. Okay, go talk to them. Okay. Okay. Bye-bye.
This is a small point, something that I want you all to consider as well. Now, when the defendant was on the stand, she testified that when the officer came into the house, which he's not left his car yet, nor at all, his car is pulled up, he's not gotten out yet, he's not walking doors. She testified on the stand yesterday that she's on the phone with 911 when the officer comes in. That's not true. Again, small point. on the phone. At this point, when the officer comes in, with her. So let's go back and let's talk about this 911 call. So in the 911 call, as I said, her first reaction, immediately after this happened, is to blame this on someone else. She blamed it on an unknown black male who came into the house and shot her down. And she says on the stand yesterday that the reason that all these lies comes out is because she wants to protect Gavin. Let's talk about that for a second. She wants to protect Gavin. What does that mean? She doesn't want Gavin to know, she says, that he shot his sister. Does that really make sense? Does that really make sense? First of all, Gavin's 2 years old. There's one of two things that are going to happen. He's either going to remember this or he's not. If Gavin remembers what happened, there's nothing she can say or do that's going to change that. If Gavin doesn't remember, he gets older and he doesn't remember.
She's acting, y'all. She putting on the act on the show.
Talking about it, she can decide it's a big family secret, we're not going to talk about it, who never knows about it. Or she can decide tell him the truth about what happened. And to say to him, Gavin, you were 2 years old. There was a gun that was not secured in the house that you got. And this is my opinion. She can say that. That's not what she chooses to do. She doesn't want to take responsibility for her actions. She absolutely doesn't. And her course of conduct from the 911 call forward blatantly shows that Ms. Howington does not want to take any responsibility for anything that happened in her life. Any responsibility. Instead, not only does she lie to the 911 operator, she gets rid of the gun. She hides this gun that was used to shoot her. She takes it outside while on the phone with 911 while her daughter is in the house having been shot. It's more important to her.
She hid the gun outside, y'all.
Put that gun outside in the dark. You can see the gun in this picture. Remember the officer testified because he has a really bright light on his hand. Those first set of pictures where you just come around that corner, you can see just how dark it is. Just how dark it is back in that corner of the house, the side of the house. Takes this gun that was used to shoot her. Her first reaction is to take this gun and to take it outside and hide it under a bush. She's conscious of something. She knows.
Yeah, I'm gonna skip it just a little bit.
So what's the chances that you were scared today, you had the gun, and you shot by mistake?
No.
That didn't happen?
No, sir.
You never got the gun until after you called 911 and you thought that you were getting in trouble for that.
Right.
So you're sticking with the fact that Antoine did this.
Yes. So here she's saying the gun that's outside is not the gun that was used to kill Destiny, which we know is not true. Then she changes her story, but she's still blaming Anton.
Is that gun the murder weapon? I'm just asking. If it is, tell us it is. If it's the weapon he used now and you took it outside, tell me the truth. Is it the murder weapon? Because I think we've got ballistics and we're going to be able to tell. I want you to hear it from your mouth. I want to hear it from the horse's mouth.
Do you want to say, yes, if you want to do it.
Yes, that's the gun that was used to kill Destiny, but she's still on an Antoine. And I submit to you what she's doing here throughout all of these interviews, as I said before, is that she makes up stories, she deflects everything from Robin Howington, and it's not until she is confronted with evidence or, like here, if we're going to do ballistics on this gun, she finally. The last thing I want to do, ladies and gentlemen, is I want to go through the elements of this offense. You all heard in your diary that what the state of Tennessee has to prove in this case. We have the burden of proving this case beyond a reasonable doubt. We talked in your diary about what that means. If you all recall, we talked about how the state has to prove the elements of the offense beyond a reasonable doubt. And so I want to walk through briefly the elements of the charged offenses in this case. The first offense that the defendant is charged with is felony murder. I anticipate you will hear from the court, and you all will have these instructions back in the jury room. So if you want to take notes, obviously you can, but you will have this information back in the jury room. Is that the defendant, or one for whom the defendant is criminally responsible, unlawfully killed Destiny Oliver. And two, that the killing was committed in the perpetration of, or the attempt to perpetrate, the alleged aggravated child neglect. That is, that the killing was closely connected to the alleged aggravated child neglect and was not a separate and distinct and independent event. And then finally, the defendant intended to commit the alleged aggravated child neglect. So those are the elements the state has to prove in this case beyond a reasonable doubt in order to find the defendant guilty of felony murder. We'll come back to that in just a second, because basically what this is that the state has to show the defendant or someone she's criminally responsible for unlawfully killed Destiny Oliver. And we know that that is the case here. And then also we have to prove the defendant intended to commit aggravated child neglect. And we have to prove the aggravated child neglect. And these are the elements for aggravated child neglect. First, that the defendant knowingly neglected a child, Destiny Oliver, so as to adversely affect her health and welfare. And ladies and gentlemen, the death of this child is an adverse effect on her health and welfare. It could be less. You can have aggravated child neglect where a child is seriously injured, not dead. But obviously, the ultimate adverse effect on your health and welfare is when somebody is deceased. And so clearly that element has been met. That the act of neglect resulted in serious bodily injury to the child. Again, serious bodily injury is defined under the law to include death. And it's undisputed in this case that Destiny Oliver is dead. We have shown you beyond reasonable doubt that second element. And that the child in this case is 8 years of age or less. And we've heard testimony in this case that Destiny is 5 years old. We heard about birthday, October, the exact date and the exact day. 5-year-old child. And so the state has proved, in this case, all of these elements. And we're going to ask you to find her guilty of aggravated child neglect. That's the second count. The third count is similar to the second count. She's not going to be punished twice for the same thing. But it's another theory of what happened. Under the law, the first element's exactly the same. The third element is exactly the same. But this time, because there's a deadly weapon involved, we're going to ask you to find her guilty. Because there is a deadly weapon that was used to accomplish this act, a firearm in this case. The defendant is also guilty of false report. She initiated a report or a statement to law enforcement concerning an offense or an incident within the officer's concern. And so there are many false reports in this case. But we are required to elect for you which specific false report that we're talking about so that we can have a nuance for it. And so in this particular case, we're going to ask for you.
She need to be charged with all of that.
But an unknown male
Y'all go ahead on and hit the like button. I appreciate that. Hit the like button. Shout out to all my
and the defendant knew the information.
mods and the viewers
We ask you to find her guilty of that offense.
and people, subscribers who've been with me from day one.
4, we're dealing with the firearm.
Count five.
Count 5, excuse me, thank you. Count 5, the firearm. The defendant knew an investigation was pending and was in progress, and the defendant concealed the firearm with the intent to impair its availability as evidence in this investigation. She took that firearm, she took it outside, into the dark, while on the phone with 911, put that firearm under the bush, and then called her friends and asked them to come get it. Clear the tampering with evidence. And then finally, attempted tampering with evidence. We're talking about here the cellular phone. The defendant knew an investigation was pending or was in progress, and the defendant,
That's what she did.
there's going to be
Tamper with
a definition of
evidence.
attempt, and then you're going to have this definition. So basically, what we're doing here is we're talking about an attempt. So we're saying the defendant attempted to alter a cellular phone with the intent to impair its availability as evidence in the investigation. What did we hear that she didn't even if we give her the benefit of the doubt and say, okay, that phone's face was broken before this happened, she still ran it under guard and tried to give it away to a lady in the bathroom. And that is very clearly meets this definition of attempted tampering with evidence. We ask you to find the So I want to go back really quick and talk for just a minute about felony murder. Because I think sometimes when people hear the word felony murder, they think, oh, murder. When we hear the word murder, most people think an intentional act. Somebody did something on purpose. Somebody did something premeditated. That's not what we're talking about here in this case. These are the elements. It doesn't have to be premeditated. It doesn't have to be on purpose, intentional. What we have to show is that there was an aggravated child neglect and the child died. And that those things were not separate and distinct. She died because of the neglect in this case. Because that gun was in a place where her child had access to it. So the last thing I want to say to you all before I sit down is that the defendant has gotten up on the stand and she has now given her version, her newest version. After 5 years of this case pending, she has now come up on the stand and given her version of what happened. And I submit to you that even if you take every single thing that she said as the gospel truth, which I don't think it would be unreasonable for you not to do that, but even if you did, if you took everything that she said on this stand as the truth, she has admitted on this stand that there was a gun in her house. In her version of events, she has no idea where it is. And it is left in her house for 2 days in a place that her 2-year-old child could find it in 2 minutes, 3 minutes, while she's outside. That's her version that she's telling now. And so again, even if you take everything she says as the gospel truth in this case, she has committed this offense.
She did.
She is guilty of these crimes. And we're going to ask you all that whenever you go back, look at the evidence, think about how she was acting throughout the course of this investigation, and that you hold her responsible. You hold her responsible for her negligence that day and find her guilty.
Good job, State. Good job. Oh Lord, here he come.
All right, ladies and gentlemen, don't discuss the case yet. You've only heard part of it. Let's take a 5-minute recess and we'll come back in here. All right.
Okay, we're gonna take a 5-minute recess on the here we go, y'all. Here we go. Here go the 5 minutes. Here we go.
I know, at least since Tuesday, you have noticed a cough. I don't want you to hold it against Ms. Howington if that has annoyed you. I got the cough drop and I'm doing the best I can for the conditions you find me in. Which is exactly what this case is about. I told you in opening statement that this is a family tragedy that the state is trying to find a way to make worse. What condition was Miss Howington in? She told them twice. Once at the house, about 2 minutes and 40 seconds into the discussion there. And again, in that interview room, about 10 minutes, within the first 10 minutes, and she has PTSD. They know she has PTSD. No one's denied that.
Hold up, y'all. I'm sorry.
For life. And they want to say, well, then she said this, it wasn't true, and this, it wasn't true. So see, that means she's guilty. Not that she's confused. In fact, not that Miss McDermott stood up there and said, let me show you this other video that happened the next day. It was 2 days later. Did she lie to you? No, she was confused. Can you imagine if she was confused in a courtroom where she works, in a job that is her profession, to deal with questions and answers and facts. Miss Howington was being interviewed on the worst day of her life, about the worst possible circumstances. And she needs to get everything right. And if we talk about why those officers might need 48 or 72 hours, think about some of the things Miss Howington told them. They talked about in that 17th story that she was telling them that on the night of the killing, that Antoine gets the gun and he takes the thing out of it. He's trying to take the thing out of it. That's what she told them happened on the 12th, and what they verified happened on the 12th. He took the gun away from her. She pulls the gun. He takes the gun away. She pulls the gun and says, leave. He won't leave. He snatches the gun from her. She doesn't shoot him. She didn't even have a finger on the trigger, because if it did, when he snatched the gun, it would have fired. She's got the gun in her hand trying to make him leave. He won't do it. He takes it, breaks it apart, throws it down, and Callie went and got it. Oliver said that, and Callie said that. And the officer testified. Mr. Riddle did question them, and yes, that's what they said about what happened on the 12th. So Callie's the last person with the gun. She tells you, I told him to put it away. Now, she's just been in this confrontation with Mr. Oliver. He's taken the gun away from her and thrown it. Callie's gone to pick it up. Do you really think she wants to deal with the gun again? She says, put it away. It's 2 days before the shooting. The state would have you ask, ma'am, why didn't you go in there the next day and check and see where that gun was? So for 2 whole days, you hadn't looked to see where your gun is? How often do you go look and see where your gun is? She tells him it's in the closet on the shelf because that's where I keep it. She tells him Gavin had to climb up there on the stool because Gavin got the gun. And remember, that's what we're charged with, that Gavin got the gun. And that Ms. Howington allowed that to happen, and that's negligence, and it resulted in a death. So, they're giving you that Gavin got the gun. She's in this room, in her mental state that she possesses at that moment. As one of you described, how could a mother be in her right mind under those circumstances? She is under those circumstances, and she's trying to figure out how the hell did Gavin get the gun? Well, he must have got on the stool. He must have got to the closet, because that's where the gun is, because that's where she keeps it. The truth of the matter is, Gavin did. And they start saying, that's not true, this is not true. And finally, she gets to it and says, Gavin did. When you look, well, you know, like the mannequin anymore. Lay that mannequin on its side. That's your shot just off the top of the couch. Off the cushions of the couch. The seating of the couch. About a 2-foot height from the floor. Not where Gavin would be if he was pointing the gun. They kept telling her that's not true. He would have to be on top of her and shooting like this. Down into her. That things are going through the couch into the floor. The couch cushion right behind her when she was lying on her side. They had all the evidence they needed to know that this was an accident. that she was not responsible for. Because they couldn't give her what they would give each other, which is 48 to 72 hours to figure out what's going on and hope they are not suffering from PTSD and medication. When she was, they had given her that 48 to 72 hours, they would have had time to know what happened. They would have had time to collect all that evidence at the scene and found the bullet in the cushion and stop telling her lies about where it should be and why it isn't there. And that must mean you did it.
She
It's
said,
not adding up. It's not adding up because you don't know what the numbers are. You haven't done the investigation. You just drugged this woman into a room and screamed at her for 4 hours and tell her all the things that you want it to be. It's clearly domestic. We do that all along. We do that. Thank you for telling us. That's what we needed for you to do. Now we're going to help her. She didn't change her story. They did. She testified yesterday and she told you. And she told Wardlaw. They kept telling me he couldn't have got on the steps. He couldn't have got on the stool. He couldn't have got on top of that closet. It couldn't happen. It's not physically possible. And they're lying. What did she answer to Wardlaw? He either climbed up on the stool or the gun wasn't where I put it. He either climbed up there or the gun wasn't where I put it. I suggest to you, let me state in proof 4 days of testimony is that this was a horrible family tragedy. And that's where it should stay. They're not claiming
whoop. Sorry. Okay. I want to get to the verdict. Come on, Judge. We can't hear you.
All right, get the jury lined up. Yeah, go ahead and mute it.
I hope you guilty. Cause you guilty. Robin, Howington. Waiting on the jury, y'all.
Nobody be on the front row right next to the jury, please.
I need to go get me some more tint and dye my hair blacker. Hope everybody having a happy Friday like I am. Been chilling all day. Children been out of school today. Come on, y'all. Y'all making me nervous. Y'all believe she guilty? Make sure you take the vote. Not guilty or hung jury. Just be honest with the situation.
All rise for the jury.
Ooh, I'm nervous. I'm nervous, y'all. She knows she guilty.
Everyone may have a seat. Waive the call for the state or the defense. If you could pass the verdict form up here, please, Mr. Morgan.
Oh, y'all, I'm so nervous. She showed them.
Mr. Marks, I understand you are the foreperson of this jury. Is that correct? Yes. I understand the jury has reached a unanimous verdict as to each of the counts contained within this indictment. Is that correct? Yes. If you would stand, please, sir. Ms. Howington, if you would stand and face the jury. Mr. Marks, as to the first count of this indictment charging first-degree felony murder, has the jury reached a unanimous verdict? Yes, we have. And that verdict is what, please?
We the jury find the defendant Robin Rebecca Howington guilty of reckless homicide.
Yes!
As to the second count alleging aggravated child neglect, has the jury reached a unanimous verdict?
Yes, sir.
That verdict is what, please?
We the jury find the defendant Robin Rebecca Howington guilty of
Yes!
child neglect.
As to the third count alleging aggravated child
Yes!
neglect, has the jury reached a unanimous verdict?
Yes, sir.
That verdict is what, please?
We the jury find the defendant Robin Rebecca Howington guilty of aggravated child
Yes!
As to the fourth count, alleging, initiating, or filing a false report to law enforcement, has the jury reached a unanimous verdict?
Yes, sir.
That verdict is what, please?
We the jury find the defendant Robin Rebecca Howington guilty of
Yes!
false report to law enforcement officer.
As to the fifth count, alleging tampering with evidence, has the jury reached a unanimous verdict? That verdict is what, please?
We the jury find the defendant Robin Rebecca Howington guilty of tampering.
And
Yes!
as to the sixth count, alleging attempted
Happy
tampering,
Friday,
has
y'all.
the jury reached a unanimous verdict?
Yes, sir.
And that verdict is what, please?
We the jury find the defendant Robin Rebecca Howington guilty of attempted tampering.
If
Yes!
that is your verdict, if you would signify by raising
Yes,
your right hand,
Jesus.
please. Let the record reflect all 12 hands are raised as either side wish for the court to poll this jury.
Thought you were going to get away with this.
All right, Ms. Howington, you may have a seat. Ladies and gentlemen, thank you very much for your hard work.
Thank
You
you.
have
Thank you,
concluded
Jesus.
Week one of your jury service. I wish I could tell you that you're done, but you're not. You've still got one more week of service. I know that we've got another case to start in here on Monday, so I'm sure I'm going to see a lot of you back on Monday morning when we're picking another jury. Have a very good weekend. Thank you very much for your service.
All right, y'all. Y'all heard that. She's guilty. She's guilty. She guilty on all counts. And we knew Robin was guilty. And she lied. She lied so many times. Y'all did a good job. Y'all really has done a good job on these trials. Yes. Y'all have really your judgment been right on point and everything. That lady knew she was guilty from the beginning. She knows she said when she came into the house, the kids was asleep. Ain't no kid thinking about shooting nobody when they sleeping. And then they haven't had no dinner. They hungry. They don't play in the park. They need to take a bath and then they need to eat and go to sleep. Robin, honey, you didn't get away with this, sister. Sorry about that. Yes. Yes. We don't want again.
Everyone may have a seat. Ms. Howington, based upon the jury's verdict of guilt finding you guilty in count one of reckless homicide, as well as count two.
Y'all go ahead on and go ahead on. I don't want to hear no more. She guilty. She already been served. She already got her point and everything. I'm about to go to the beauty supply place and get me stuff for my hair and get it, do my hair, dye it black some more. And guilty, guilty, guilty. That's right. Camper, come on, please. But we gonna have a good time, y'all. I'm gonna go ahead on and do something, go to the beauty supply place and do something to my hair so we can come back and have a good time on a Friday, okay? We're gonna have a good time. We've been working all week with these cases. Y'all done did an awesome job. Mars done been there for me. Y'all done been there for me. Y'all done been up for me. Y'all done been awake for me. Y'all done, just completely did y'all job this week. I want to give a shout out to everybody. And I'll be back later on, y'all. Y'all check out my TikTok now. I'm gonna make some more TikToks. I did some little dancing last night. Yeah. I see y'all later. Out of here. Ooh, see you later. Okay, baby.